In our last videos, we talked about what raising investment means in practice and some of the documents you can expect to see when raising investment, including shareholders agreements and articles of association. And we talked about some of the provisions that come up in those documents. And in these next videos, we're going to talk about those provisions in a bit more detail, and in particular focus on points of negotiation between founders and investors. And in this first video, we're going to be focusing on the shareholders agreement.
So one thing that investors will ask for is information rights. Information rights under the Companies Act are quite limited. So a shareholder would be entitled to see, for example, just annual accounts, but they wouldn't be entitled to more frequent financial reports on a company. For founders, they want to limit the information available to investors as they want to spend most of the time actually running the business rather than preparing these reports. For investors, they need the information to see how their investment is doing and to kind of monitor their investment. It's all about finding the right balance between, on the one hand, how much information an investor needs to monitor their investment, and on the other hand, how onerous it would be for the founders to actually prepare these reports. So the type of report and the frequency of report will be set out within the shareholders agreement, but there's nothing stopping the founders from maybe catching up with the investors on a more informal basis. So they may send round kind of touching base emails in between these more formal reports. So it's all about finding the right balance and what works for the company and its investors.
The directors are responsible for the day-to-day running of the company, and there are very few decisions under the Companies Act that have to go to the shareholders for approval. And so as an investor, being quite a small shareholder in the company, there'll be very few decisions that you can maybe influence. So what's common to include in the shareholders agreement is what's known as investor consent matters. And these are a list of matters which the directors have to go to the shareholders for approval. And again, with the information rights, the right balance has to be struck with this list of matters between them being kind of the key points that, for investors could affect their investment or the value of the company, and not that list not being so extensive that the directors are having to go to the shareholders for approval too often. So as an example, some matters that the investors might want to include are the company taking on debts, the company selling off assets, the company issuing more shares. Whereas for the founders, they might be happy to include the company taking on debts, but want that to be only over a certain level. Or they might be happy to include the company selling off assets, but only if they were selling the majority of assets or key assets like intellectual property. So again, the right balance has to be struck between that list of matters. And the other thing to think about is who has to approve those matters. So for the investors, you'll want to make sure that it is investor approval. So the directors have to go to the investors for approval rather than going to the shareholders as a group, because obviously the founders at that stage will probably still have a large percentage of the shareholding. So you want that for investors, you want that to be a list of investor consent matters. But for the founders, you don't want it to be, say, unanimous approval of the investors, because you don't want one investor to be able to block a vote. So often it's the majority of the investors that need to agree those points.
So in addition to consent matters, investors may also want to have the right to appoint someone onto the board. So the investors would want to do this so that their interests are represented, and also so that they can have someone who can feed back to them about how the company is being run, as the directors of the company have the day-to-day management and control of the company. Usually the founders will have board control, as it could reflect their majority shareholding in the company. One way to do so would be to appoint a non-executive director, but this doesn't necessarily have to be one of the directors or investors themselves. For founders, they may be happy to have a non-executive director on board, and it actually could be quite valuable to them, because if the NED is a experienced entrepreneur, this could bring expertise to the board that the founders might not have, especially if it's the first time running a company. So founders, although they may be happy to give them this representation, right, they would want to make sure that the investors as a group has the right to appoint someone to the board, rather than each investor has the right to do so. An alternative as well is also for the founders to grant the investors the right to send an observer to board meetings. So this observer would attend the board meetings and feed back to the investors, but they wouldn't take part in the board decisions. So that's another route in letting the investors have the right to monitor their investment without compromising founder control at board level.
So everything that we've talked about so far relates to rights and provisions which apply once the investment has been made going forward. But another thing to think about is whether any warranties are going to be given in the investment agreement or shareholders agreement when the investment is made. So a warranty is a statement about the company or the business which is given when the investment is made. And if that statement proves to be incorrect, then the investor could bring a claim for breach of warranty. So I'm going to refer to the example that I gave in the last video, which was if your statement, your warranty, is that the company is not involved in any litigation, but at the time the investment was made, the company had a dispute relating to its intellectual property and it hadn't told the investor about that, then the investor could bring a claim for breach of warranty. So there are a few things to talk about there. Firstly, whether a warranty is going to be given at all, and whether investors will normally want at least some warranties, but the extent of those warranties will depend on how long the company's been existent, how long the business has been running. So, for example, if it's a brand new business or company and it really hasn't done anything yet, then your warranties might be very limited, just for example, relating to what the current shareholding is. Whereas if the company has been running for a number of years, has employees, has contracts, has assets, then the investors might want some more extensive warranties. And so the next thing to think about if we are going to have warranties is who is giving those warranties. The founders will want those warranties to just be given by the company because it's the company that's receiving the investment and receiving the money. Whereas the investors might want the founders to also give those warranties personally. And this is because, they'll want the founders to have some skin in the game to focus their minds on these warranties. And then the next thing to think about is limitations around these warranties. So if there was going to be a claim, there's normally limitations around, for example, the period within which that claim can be brought and caps on liability. So if founders are giving warranties, then caps on liability are going to be very key for them as well. And then the last thing to think about is if you're giving warranties, then also there's normally a disclosure process. So there's normally a disclosure letter. So this is basically a list of matters which the company, the founders, are disclosing against those statements. So going back to the example I gave at the beginning, if your warranty is the company's not involved in any litigation, and in your disclosure letter the founders told the investors about this dispute regarding IP, then the investor wouldn't then be able to bring a claim for breach because they were told about that before when the warranty was given.
And the warranties, they supplement the due diligence that the investors are doing on the company. So as mentioned in the last video, as the investors have invested money into the company, they're not likely to make a claim for a breach of warranty. But then that actually depends on what type of breach it is. So that was a brief overview of the key founder and investor protections found in shareholders agreements. In our next video, we'll talk about the key founder and shareholder protections in the company's articles of association.